your old buddy, Brian Parker. I'm gonna do some quick tip hits today, or quick hit tips. Anyway, today we're gonna understand the securitization letter request. Why should you demand proof that the person or company suing you has the right to do that? So let's look at what is first. In most creditor lawsuits, you're gonna wanna ask this question. Shazam, what is securitization? Securitization is where banks and lenders often sell your loan or credit card debt to trusts or investment pools called asset-backed securities, ABS. When this happens, ownership of the debt separates from the bank that gave you the original loan. You can use that in debt buy cases, which is like not your primary defense, but mostly use it as a primary defense in creditor cases, and it should merit you better settlements. Here's why it can matter. Shazam. Only the true owner of the debt has the legal right to sue you. You've heard me say standing. You can't sue anybody unless you have standing. If your debt was securitized, then that company contacting you may not legally own it. So what do? You've got to prove that they don't have ownership, or their ownership is separated, as we said, in the ABS. So you send this securitization request letter that I have on killdebt.com. Here's what you do with the letter. Shazam. These are 3 quick pro tips. What this letter demands. Proof of who owns the servicing rights. A servicer is not a collector or owner. Identification of the trust or entity that owns the debt. Copies of the notices you should have received after any sale. In some states, you're required to receive notices if your debt is sold. Copies of the pooling and service agreement. That is like the forward flow agreement in debt buy cases. It tells you all the rights and rules that creditors have to live by. Production of the forward flow purchase sale agreement, which is another pooling and service agreement, but in a debt buyer context. This will help you in the following ways. Shazam. It will create a true written record of ownership, and you can use that, go in your defense, in your answer and counter affidavit. This forces the creditor or the true owner to produce documents that show who really owns this debt. It can reveal, and that's why you do the securitization letter, gaps in the ownership or in the truth of their lawsuit that they're bringing. And remember, they usually bring crap lawsuits, so that'll help push them over the cliff. It will slow down any aggressive collection efforts by a debt collector that's got hundreds or thousands of these lawsuits and just wants to move you along. If you be a problem parker, you'll have a great problem parker solution. So send this letter certified, return receipt requested, save a copy of the signed letter. Remember, the rule is keep a paper trail, register by mail, monitor their response. And remember, even a non-response is a response, because down the road when the court's going, hey, what's going on here? You go, look, I tried to find out and offered them an opportunity to show me exactly who owns this debt, and they blew me off. Remember also that you want to, let me put this up there, it's a nice little hint. Shazam, match the lawyer's stuff to the creditor stuff. What do I mean by that? The debt collector is mostly in the dark. The attorney is mostly in the dark. He's got hundreds or thousands of these cases. He's not putting any effort. He thinks he's just going to steamroll over you. Well, if you're doing all this work, the creditor, when he gets one of these letters, is just going to tell you what you want. You may have to do a follow-up letter. There's no communication between the creditor and the lawyer showing you that they're on the same sheet of music. It will contradict each other, and you can use that in your defense of your lawyer. So go to killdebt.com for more templates, videos, step-by-step guides. Protect yourself, fight back, kill the debt. Thank you.